And again, this is the same kind of argument that when people bring up abortion, so to speak, and they always want to use the anecdotal examples to justify the reason why abortion should be legal. Like for the woman who gets raped or the child who's molested by her father and she gets impregnated by him, should they have to keep the baby? And therefore, if you think that's wrong, then you should automatically be pro-abortion all the way. And people don't like when we say, well, we're not using those examples, and especially in those cases, even if those things do happen, even though they're rare. According to the Guttmacher Institute, 99% of abortions are for convenience, but the rape and the molestation does happen. But even in those instances, I think the rapist should die, and the father or the uncle, whoever abused the young girl, should die, because that is a very personal act, and you are not denying really and attacking the person who is made in God's image, a woman who's made in God's image. And for that violation, I think you should die. That's according to Old Testament law. But using those anecdotal examples to justify abortion is wrong and should not be held to. But a lot of people on the left, on the political left, and people who are not saved use that argument and say, well, what about these exceptions? Therefore, the whole case of abortion should be made based on those anecdotal examples. But when it comes to these anecdotal examples of people who are poor and now pretty much being manipulated into killing themselves, and people are saying, hey, hold on, this is a slippery slope, this is something dangerous, then all of a sudden the Supreme Court of Canada says, oh, we don't need to worry about that. Those are just anecdotal examples. So it's unbalanced reasoning depending on the political issue or the moral issue at hand. Mr. Zhu continues in his article. He says the next year, when the Canadian Parliament enacted Bill C-7, a sweeping euthanasia law which repealed the, quote, reasonably foreseeable, end quote, requirement, and the requirement that the condition should be, quote, terminal. Now, as long as someone is suffering from an illness or disability which cannot be relieved under conditions that you consider acceptable, which is what he quotes in the language of that law. So who's determining what's acceptable? They can take advantage of what is now known euphemistically as medical assistance in dying, MAID for short, for free. Soon enough, Canadians from across the country discovered that although they would otherwise prefer to live, they were too poor to improve their conditions to a degree which was acceptable. So these are people now who cannot afford the treatment that they need to stay alive because they want to stay alive, but because they can't afford it, now they're being ushered into this category of, well, maybe we should put these people to death. And lest you think that this is something that's still merciful, the money gets wrapped up into the reasonings here, and you'll see in just a second. So he continues in his article and he says, not coincidentally, Canada has some of the lowest social care spending of any industrialized country. Palliative care is only accessible to a minority, and waiting times in the public healthcare sector can be unbearable to the point where the same Supreme Court, which legalized euthanasia, declared those waiting times to be a violation of the right to life back in 2005. So it's so ironic that the same Supreme Court who is now legalizing euthanasia back about 17 years ago, declared that if you have to wait in line too long to get the necessary care that you need to stay alive, that's going against your right to life. That's unconstitutional. But now, 17 years later, they're now legalizing the death of these same people who they thought were being violated of the right to life because the lines to get the care that they needed to stay alive was too long.